The Democratic Alliance has filed court papers challenging the Expropriation Act. President Cyril Ramaphosa signed the controversial act into law last month, and it outlines how the expropriation of land can take place, as well as how compensation can be determined. But the DA says the act is unconstitutional, both substantively and procedurally, and wants the Western Cape High Court to nullify it in its entirety. The act has drawn mixed reactions from political parties and organizations, including US President Donald Trump, who since halted funding to South Africa while America investigates claims of land confiscation. DA Federal Council Chairperson Helen Zille joins me for more on this. Helen, good morning, and thanks as always for your time. Appreciated. Your 111-page petition to the court seems to turn on two main principles, one relating to procedure and the other relating to the period by which a disputed expropriation can be resolved by a court. Let's start with the first one in Section 65(1)(b) of the Act and how the provinces voted.
Right, let me say as a start that we are going on those grounds because they're the easiest wins. That doesn't mean to say that those are the only problems we have with the Act. We have substantively far greater ideological problems with the Act, but those are the two issues that you can get your easiest wins on. And of course, when you do go to court, you take your points that are the strongest and the most likely to get the outcome that you're aiming for. So the first one deals with the way that the various provinces voted in the NCOP. Now, there is a process prescribed in law, constitutional process, legal process, and then also covered by the rules of the various provinces, the regulations thereof, how a mandate has to be given to the NCOP. And in 5 out of the 7 provinces that voted for the bill, only 7 provinces voted for the bill, but out of the 5 of the 7 that voted for the bill, 5 of them got the process completely wrong, which actually nullifies that act in its entirety, because from the beginning the process was wrong. That's the first point that we're taking. The second point that we're taking is the point that there is a complete confusion in the act itself about the process of expropriating land. It's got everything to do with the sequencing of when you go to court and when you get a valuation and when you challenge it and what you have to have before the others. And there are 2 completely contradictory paragraphs pertaining to that in the Act. Now, that's a very easy line to take because the Constitution says that every piece of legislation has to be clearly understandable. And this clearly is not understandable because it gives 2 contradictory processes. So those are the best and easiest and shortest methods of challenging this act. But we have far more substantive problems with it.
And we'll come maybe to some of those ideological problems you say that you have with the Act, Helen. Just to go back into the second piece relating to landowners needing to approach a court within 180 days of receiving a notice of expropriation. Why do you believe the time frame is problematic? Of course, there are issues around mediation and so on that are encompassed therein. But I'd like for you to just explain a little bit further on that one as well.
No, that time frame is not problematic. What is problematic in that clause is the fact that the government can decide to expropriate your land for far less than its value or even for nil compensation. And then the onus is on you to go to court and have all the expense of a court case to fight that. Now, that's a big problem. Now, obviously, there is going to be an arbitrator, and then many of the claims are going to be overseen by a court. But in Section 12(4), it goes to a land claims court, which we don't have any confidence in, to be quite frank. And we believe that this is just a scheme to get into place the ANC's Congress resolution of 2017 to be able to take people's land away without compensation. So the timing and the sequencing problem in the Act is when you can go to court, whether you first have to have a valuation, whether the evaluation comes at the end of the process, and how the sequencing works. That's not our main problem with the Act, but it's the easiest constitutional win in court because the Act is not clear and it's not interpretable by ordinary people. So it is completely contradictory, confusing, and that makes it unconstitutional.
All right, given that you've taken these 2 pieces, then, as you say, just to paraphrase you, lowest hanging fruit, this is probably an easy win that you can go for. If the court doesn't go with you on those two tenets that you're seeking relief on, or you're seeking the act in its entirety to be declared unconstitutional on, what happens then?
Well, I don't like to speculate about court cases. I really don't. We take one day at a time. We put our strongest case forward that we can, and then we see what the court says.
Yeah. And the reason I'm asking, and maybe you can share perhaps what your legal team has shared with you, the definitional, perhaps the first one, as you say, is more on a procedural issue, which could be something that's easily clarified and decided upon. But on the confusion around the process and the second piece of the litigation around the definition, what is your understanding of redefining the languaging in an act, just redefining it without affecting the act in its entirety? What have you heard from your legal team on that?
No, we will oppose that very strongly. But if we win on the first point, the law has to go back to the very beginning, and then we can fight about the contents and the wording after that.
All right. So the first respondent, Helen, is in your papers is the Minister of Public Works and Infrastructure, Dean Macpherson, a DA minister in the GNU. And while he did advise the president against signing the bill, we heard Macpherson just last Monday in Cape Town assuring investors there would be no land grabs or confiscation of land in South Africa. He said, "I want to be unequivocal. No one in South Africa is having their land confiscated. As the Minister of Public Works and Infrastructure, land grabs will never be allowed. This is my commitment to the people of South Africa and our partners around the world." He also said that the Act set out a clear legal framework under which expropriation might take place, always with due process and court oversight. In the end, though, how do you reconcile his utterances and what you're saying now with this particular court bid?
Well, we're taking it to court because there isn't a clear legal framework. It's a very confusing and contradictory legal framework. And that was the basis on which Dean Macpherson, Minister Macpherson, argued with the president or presented to the president the case against signing the bill. But also, Dean Macpherson is the minister now, and we are sure that there won't be arbitrary land grabs while the DA has that portfolio. But you don't legislate for the best of times, you legislate for the worst of times. And we had a big problem because we had a constitution and legislation that presumed a Nelson Mandela, and then we got a Jacob Zuma. And you've got to legislate for the worst possible scenarios, not the best possible scenarios.
Yeah, but Helen, he said, and these are his words, that it set out a clear legal framework under which expropriation might take place. He didn't add a caveat that as long as he's a DA minister or as long as there's a DA minister in control of this portfolio. What are you actually saying to investors then?
You did say that Dean says that I am the Minister of Public Works and I can assure investors X and Y. You've just read that. But the truth of the matter is that the very basis on which Dean warned the president not to sign the Expropriation Act is that there is not a clear legal framework. There is a clear legal framework in the Restitution of Land Rights Act, which we fully support, because that is where restitution, given the injustices of the past, has to be dealt with. And we also fully support the two Land Reform Acts, under which restitution also happens. But Expropriation Act is not supposed to be dealing with those things. It is supposed to be dealing with the state's need for land for infrastructure, bridges, roads, rail, etc., dams. And that's why it falls under the Minister of Infrastructure. This is not under the minister responsible for land reform. So the important thing is to sneak the other kind of expropriation into this act is wrong, ab initio, because 3 other acts exist for this process. And we do not believe that the wording gives proper protection into the future.
You've said, Helen, that we have not forgotten that the apartheid government used similar powers to forcibly remove communities from their land, often with inadequate compensation or none at all. This history teaches us that true redress requires protecting property rights, ensuring that no government is ever given unchecked expropriation powers ever again. Just explain a little bit further your sentiments there, which goes back to the first point that you were making around having ideological differences with the Act, and perhaps in that response as well, your alternative then urgently to address the issue of land in the country?
Amon, well, the first point that the DA makes from an ideological or political philosophy perspective is that any country with a successful and growing economy and a prosperous community is based on some core principles: constitutionalism, the rule of law, a market-based economy, which has to secure property ownership as a right. And any country that violates that has gone into a vicious spiral downhill and has impoverished its own people. So that's the point of departure that we start from. That does not mean to say that we don't support restitution and land reform. We absolutely do. But there are 3 acts that deal with it, not these kind of arbitrary processes that the government is trying to set up now in a different act that was not meant for this purpose at all. Now, the apartheid government, in a parliamentary democracy for a small minority of the population only, had those powers. And that's why we saw the Group Areas Act. That's why we saw communities living in places like Newlands in Cape Town, living in places like Harfield Village, living in places like District 6. They could be arbitrarily removed from their land with very minimal compensation. And we must learn from our history. That was a disastrous period. It impoverished a lot of people, and its scars are still obvious today.
Can I just go into that? Because you say we've not forgotten that the apartheid government used similar powers, and you've gone further now to explain what those similar powers are, the constitution of that parliament. And you use the term now parliamentary democracy, but for a small minority of people. That in no way resembles the power sharing that we have in South Africa today, as exemplified and characterized by the GNU. Furthermore, if we think about the pieces of law that emboldened the apartheid government to act in the way that it did, we're thinking about the 1913 Natives Land Act, which in no way resembles what we have today in terms of the Expropriation Act. That act allowed people to be arbitrarily dispossessed of their land with no redress, no compensation, taken to townships and communities where they had no choice about going to. Are you saying that's what you think this act is emboldening and empowering this government to do?
I think that you're confusing the Natives Land Act, which was a diabolical piece of legislation, with the Expropriation Act. They're 2 very different things. But the point that remains valid is whatever government is in place now, you legislate to ensure that rights in the Constitution are protected. You don't legislate in ways that creates big openings for those rights to be undermined and destroyed in a future where you can't control who comes to power. You legislate for a worst-case scenario, not a best-case scenario.
Can I just also ask, Helen, in your video yesterday, I was just watching the video recording your filing, explaining what route you were taking, and I just thought out of interest, I'll go to the comments. I'm not sure if you might be busy, not sure if you ever read the comments of people on different pieces of content that you post. But there were a lot of people, and the majority, again, this is anecdotal, it's just a little dipstick of what, the sentiment is. It's by no means representative of everyone who's voted for the DA. But go back and have a look at some of those comments of people saying, we feel let down, this is too late, this is nonsense, and so on. How do you rally your voting base now, people who feel that the course of action you've embarked on hitherto has been maybe a betrayal or not exactly what they had anticipated or had in mind? How do you win people who might be doubting you right now?
Iman, we're doing the right thing. We're challenging this act in court. We will protect property rights for all South Africans. We will extend property rights to all South Africans through the appropriate legislation. And we will protect South Africans from a power-abusing government. That is the DA's pledge. That is what we're committed to doing. And that is what we're doing now in challenging this act in court.
DA Federal Chair Helen Zille, thank you for your time this morning. We appreciate it.